Hello, and welcome to the course, What You Need to Know About Employment Agreements for the Healthcare Professional. My name is Stephanie Roden, and I'm the owner and founder of Roden Legal PC, a law firm that works exclusively with healthcare practitioners. I help them with the business management of their practices so that they can concentrate on the patient care. Today, I'm going to be talking to you with respect to employment agreements and what the individual practitioner needs to know and understand prior to signing and joining a practice. Whenever a licensed professional looks for a practice to join, either after they have graduated residency or fellowship, or if they're going from practice to practice, there are many different issues, including financial and legal, that they need to make sure that they are aware of. And it is always wise for them to speak to not just an attorney, but also an accountant and or their financial advisor while they are working on negotiating the contract. Once they can understand the different areas of the contract that can greatly affect them in moving forward in their career, they would then be able to sign the contract and move forward and join the practice. Now, back in the day, these contracts used to just be handled by a mere handshake. That has changed over time for obvious reasons. Now, a lot of these contracts can be anywhere from 5 to 10 pages minimally, but generally they are around 20 pages. And within these contracts, there are a number of different clauses that can be detriment to the individual practitioner. And that's what this course is going to go into. The purpose of the contract is to help them understand, and by them, I mean the physician or the dentist, the healthcare practitioner. It's to make them understand exactly what the expectations are of the job itself, of what they can rely on, what the employer is expecting of them, and what would happen if either an issue arose during the course of the agreement, or they decided to terminate the agreement early, or the practice decided to let them go prior to the expiration of the contract. Without understanding those terms of the contract, it can be very difficult for the practitioner to be able to continue their career in the way that they want to be. And by that, I mean whether they will be able to join another practice, whether they will be able to work in the area that they have studied in, and the specialty, possibly even the geographical area. And we'll get into that more throughout this course. Okay, what does the contract actually consist of? Now, there are many areas that the contract has, but there are 7 crucial areas that I'm going to go into more detail about during this course. And those areas are compensation, benefits, termination, restrictive covenants, future position with the practice, which would mean either a partnership or a shareholder, HIPAA, and billing procedures. So let's start with compensation. Compensation can be paid out to the practitioner as an employee in 3 different ways. 1 is a straight salary per year. 2, percentage based on production. And 3, percentage based on net collections. So let's start with the straight salary. The straight salary is the easiest way. And basically, it means that the physician would be receiving an annual compensation of, let's say, $250,000 for a contract year. Now, within the terms of the contract, it must be defined of exactly what that contract year is. Is the contract year from January 1st to December 31st, and therefore prorated during that year should the contract start at some point after January 1st? Or is a contract year starting on the date that the contract commences with the physician and then ending the day before that same date the following year, so that regardless of when it starts during the calendar year, it would always be a contract year up until the other date. And the reason why this is important is so that the physician can understand the benefits, the PTO, malpractice, and other things of that nature, which we'll get into later.